Hey Cyber Class, it's Professor Opterbeck. Welcome to week 12. Yes, we are almost at the end of this semester, which I know is hard to believe. Good job last week in the discussion forums. I hope you got a little bit of a taste for what some of these risk management tools look like, and that you had some fun looking at that and playing with it and getting acquainted with the problem for our final assignments. So this week we're going to step into looking at cyber insurance, and this is a really good segue from measuring risk to now thinking about what the organization has to do to manage risk. And when you think of risk management, certainly as a lawyer, when you think of risk management, one of the first things you should always think about is insurance. Is there a way to insure against this risk? And there's pretty much a way to insure against almost everything. The question is, what the policy is going to say, what it's going to cover, and what it's going to cost. So the main piece of the content for this week is some business level articles about cyber insurance and an interview that I did with my friend John Wallach, who's a partner at Gibbons, who does cyber insurance and other kinds of insurance litigation and counseling work. So I did that interview last year, actually, just after we shut down, or not long after we shut down because of the pandemic. So, the video quality isn't as good as it could be, but it's still a good interview. So take a look at that. I also posted John's slides, which give a little bit more background on the cyber insurance market. So I want to talk a little bit about the P.F. Chang's case, which I gave you to read, and explain a little bit what's going on and why I gave it to you. So P.F. Chang's is one of the few cases, even now, that's out there, reported cases on a cyber risk insurance coverage litigation. Now, if you're not familiar with this whole field, an insurance policy is a contract. It's a contract between the insurer and the insured. The insured agrees to provide the insurer with certain information, which helps the insurer determine the risk and what it's willing to cover, and to pay the insurer premiums, that is a contract fee for the insurance coverage for whatever term and under whatever conditions the policy contract says, and the insurer in turn agrees to cover certain risks and to reimburse the insured if some of those risks are realized. Now, as you might gather, this can be a pretty sophisticated kind of contract, and the insured is going to want to define what is covered and make sure that the contract states what is covered and under what circumstances, and the insurer is going to want to clearly state what is covered and what isn't. So there's going to be definitions of what is covered, and there's going to be exclusions that are trying to list what is not covered. So there's not infrequently litigation between an insurer and the insured about whether a claimed loss that the insured has suffered is really covered, either affirmatively under the terms of coverage, and or whether it is excluded under some exclusion in the policy. And essentially this is contract litigation. Now, there are some special rules in insurance contract coverage cases about the way that the contract should be interpreted. There is a lot of case law as to certain kinds of policies. So your CGL, or commercial general liability policy, is a very well written. So that's if someone slips and falls in the store that you're running and breaks their ankle or something, right? The terms and the exclusions, there's a lot of litigation, so there's a lot of interpretation and case law about that, and then there are kind of canons of construction of these contracts. There's just not a lot of case law, hardly any at all, in cyber risk. So I'm going to explain to you now what's actually going on in the P.F. Chang's case, because I happen to think it's really interesting. I gave you as optional reading, you don't need to read it, it's not tested on in any way, an article that I wrote a few years ago on the economic loss doctrine in negligence claims in the card payment industry. That article does touch on insurance, but it's primarily about tort rules. But also what it does is it explains how the payment card industry works. And to me, this is just really interesting. I love this sort of diving into kind of the economics and the law of how the world actually works. It's also important for cyber risk and data breaches because many of the cases that cause serious expense are cases that involve exfiltration of customer credit card information. And I'm guessing, I know this has happened to me several times, but probably for most of you, if you have a credit card or a debit card, there's been some point or another at which the company has alerted you to, or you have discovered a fraudulent charge because the card somehow was compromised. And what you probably know from that, and if you haven't experienced it, you can learn this now. If it's fraud, you, the cardholder, are not liable for that expense. You're going to be reimbursed for that expense. And so why that happens and how that relates to cybersecurity risk and insurance is a really interesting story and relates to this P.F. Chang's case. So the slide that I'm showing you right now is a diagram of mine that's in my article. It's a little bit simplified, but it's fair, of how card payment networks work, and then I'll explain some of these risks. So first thing, let's look at the card customer. So you or I have a credit card or a debit card. There is a bank behind that card. Now your card might, have a brand associated, like maybe Amazon or Disney or, American Airlines or whatever it is that's providing you some kind of perks or benefits. But ultimately, there is a bank or some financial institution that's standing behind that card. Now, I'm primarily talking here about Visa and MasterCard. It's a little bit different with the Discover card, and it's a little bit different with American Express. Really, Visa, MasterCard, Discover, and American Express are the major card brands. Visa and MasterCard are by far the largest. There's some other alternative things like PayPal has financing and things like that. There's always some arrangement like this, but we're going to focus on Visa and MasterCard. So there's a bank that stands behind that. The bank issues you this card. So you have a contract, I'll put my contract here, with the bank. The bank is extending you credit. So here's this, the bank is extending you credit. And based on whatever the credit history the bank did, it's giving you an interest rate, and it's giving you a credit limit. It's a little different if it's a debit card. Obviously, that's money that you have to have deposited in the bank, and in that case, the bank isn't extending you credit, but it's extending you transaction services. And then for a credit card, you're agreeing to pay interest. So you have an interest rate, and unless you're paying up within the period before interest kicks in, then you have to pay interest. With a debit card, there's going to be somewhere some kind of service fee to the bank for having your money in the bank. All right, so that's the first piece in the chain, the issuer bank and the card customer. Then on the other side, there's a merchant. So there's some store, a website, whatever it is that you, the customer, are going to be buying some kind of goods or services from. And in doing that, you're agreeing to a purchase price for those goods or services. Usually when we're just doing a consumer transaction, you're buying something on Amazon, there's not sort of a negotiated term. It's just, here's the offer, you can buy this pair of glasses for $20, reading glasses for $20, and if you want it, you can pay the money, right? All right, so then the merchant, how is the merchant getting money, and how is the merchant processing? You're doing this through a credit or debit card, how are they doing it? The merchant also has to have a relationship with a bank. And in the lexicon of the card payment system, these are called acquirer banks. What the acquirer banks are doing is they're acquiring customers, merchants, and they're providing them a service. So the service that they're providing, so I've clicked on the button, I want this pair of reading glasses, I'm paying the $20, my card information is going to the merchant, then basically instantaneously the merchant is transmitting that information to the bank, and the bank is transmitting the funds to the merchant. So the merchant is actually getting its money from this other bank called the acquirer bank. So the merchant's getting a payment. The acquirer banks are making their money on something that's called a discount. So if I'm paying $20 for these glasses, then the merchant might actually be getting $19.95 or something like that from the acquirer bank. So the acquirer bank is keeping 5 cents of every transaction or something along those lines. And that is how the acquiring bank basically is making its money. Okay, well now the acquirer bank has discharged money to the merchant. It's made a little bit on the discount, assuming it gets the rest of the money back. How does it get the rest of the money back? Well, now there is a contract or an interaction between the acquiring bank and the issuing bank. So again, a lot of this is happening almost instantaneously. It is all happening over electronic networks that are either established by the brand or in some cases are established by another entity, which I won't get into much details about, called a payment card processor that then also has a contract with the brand. So the acquiring bank transmits information to the issuer bank and says, this customer of yours used a card to pay $20 for these glasses. I have discharged the money to the merchant, and the issuer bank then is going to pay the money back to the acquirer bank. Now, the issuer bank is getting a little vague, and I'm not a sports bettor, but if you are, you'll know what that term means, right? What's the dealer, the person who's setting up the transaction taking, right? They're taking a little bit of a fee. So whatever the acquirer bank is making off of this, there's a little bit that gets shaved off by the issuer bank. They're making a fee here as well as on the interest. And the issuer bank is discharging the money back to the acquirer bank. So what you should see here is there's this money, right, that's flowing through this contractual system. At each point in the system, there's some little bits of money being made by all of the players in the chain, except of course for the customer you're paying. Now, what about the card brand, Visa or MasterCard? Both the issuer banks and the acquirer banks have master contracts with Visa or MasterCard or American Express or Discover. They're paying membership dues and often other fees per transaction as well. So there's also a little bit, again, usually pennies on the dollar that's getting shaved off. And the same with the acquiring bank. And what are they getting in return? They're getting the brand. The brand matters a lot in the market. And they're also getting the network services. That is this whole electronic network that is allowing all of these transactions to happen so seamlessly and rapidly. Now again, there are other parties, these payment processors that can get involved in aggregating some of these contractual relationships, but they're ultimately going to relate back to the card brands' networks. In many ways, the card brands are their own form of commercial intranet, and a vast one, billions and billions and billions of dollars flowing across it around the globe. So it is functioning sort of in its own way as its own sort of secure space in a lot of ways. All right, I just want to go here and erase my ink to make this a little more clear. Now, as we're saying here, all of these spaces are contracts. 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 This is one of the things that legally and economically makes it so interesting to me. It's a form of, if you remember from our internet law class, it's a form of private ordering. Almost all of this is structured by contracts, and that, of course, is backed up by contract law, but it's not a form of public law. It's not a treaty. It's not a government regulation. It's private ordering. Well, so what happens if there's fraud? And in the P.F. Chang case, and what happens in many of these cases, not all of them, but many, if not most of them, the merchant gets hacked. So the merchant has suffered some kind of data breach, and as a result of that, some credit card information, because of a prior purchase or some other prior interaction of some set of customers, has been compromised, and a bad guy gets it and makes a fraudulent transaction. As part of this agreement between the issuer bank and the card brand, the issuer bank is required contractually to reimburse the customer for the loss of fraud. So now, let's say that because I bought these glasses from that merchant, they have my card on file, they suffer a breach, my card information is sold on the dark web, somebody buys that and uses my card number to buy, $150 worth of gas at a gas station, a not uncommon way to launder stolen credit cards. So I'm at $150. My issuer bank will either notify me through its own program, or I might notice it, and the issuer bank is required to reimburse me that $150. So they're out $150. Now, if there's a million customers from that issuer bank who are compromised, that money adds up really quick. Even if there's 100,000, right, that money starts to add up. So what happens? Is the issuer bank stuck holding the bag, or is the merchant liable in some way to reimburse the issuer bank? Well, the answer to that question is going to depend on these networks of agreements that all of these entities in this chain have to agree to ultimately with the brand. And the short answer is that those agreements have security requirements, and the kind of somewhat older form of it was called PCI DSS. But there's a whole set of security requirements. And if the merchant has not complied with those requirements, essentially the contract in this case is defining due care. If the merchant has not complied with those requirements, then the merchant contractually is going to be on the hook to reimburse the issuer bank. There are some cases where it's the acquirer bank that has been breached, and again, there's issues about PCI DSS. So sometimes the issuer bank might be left holding the bag for these reimbursements, but when there is a data breach, kind of fraud, there's a requirement in the set of rules, is like this thick, in the card brand networks. Within the rules, there's a requirement of an audit to see what happened, and then when that is done, the amount that the issuer bank has had to pay in reimbursement to the card customer, as well as sometimes amounts that get mangled up in these transactions in the middle, because remember, you've got a fraudulent transaction, often with another merchant. So there are fees in here, there's a transaction that's going this way, there are fees in the middle there. So there are a lot of things that get sort of bent out of shape in the whole payment transaction network when there is a fraud. So a detailed audit will be done within the card brand network, and that audit, under the terms of those contracts, will then impose fines and penalties, and otherwise adjust, kind of require payments back and forth among the merchant, the issuer bank, and the acquirer bank. So one thing you can notice here, which again is part of what I find really interesting about this is a form of insurance. You don't have an insurer in the traditional sense of an insurer yet in this chain, but what you have is a way of adjusting risk that says, in the event of fraud, we're going to do an investigation, and that's going to determine, who bears what parts of these costs. So here's where the insurance comes in. If you're the merchant, the cyber insurance comes in. You know that at some point in all of this happening, you're facing liabilities. And an entity like P.F. Chang's is facing some really significant risks. They're a restaurant chain. They have lots of individual restaurants out there. Restaurant chains are pretty vulnerable. They're processing lots of credit and debit card transactions every day, and each individual store is liable, and if someone gets into the store, they might get into the whole network. There's a lot of risk there. So you're going to want to think about cyber risk insurance, and of course the contractual transaction there, you're paying premiums, and the insurer is providing you coverage according to the terms and exclusions of that insurance policy. So here, P.F. Chang's had cyber insurance, and the insurer paid claims for direct costs from this breach of forensic investigation, of legal work to determine how to notify consumers under state data breach laws, and advising the merchant on steps to kind of secure and deal with the possibility of civil lawsuits. Those sorts of initial first-party risks the insurer covered. But as part of all this, as part of the audit done by the card brand, one of the things the card brand determined is that there were certain costs and fees that and penalties under the card brand agreements that the acquirer bank was responsible to pay to the brand. And the acquirer bank then, according to its agreements with the merchant, charged some of those costs and fees to the merchant. And this is the way this network of contracts within the card brand works. It's the way that risk is spread within that network. So P.F. Chang's then said those losses should be covered by the insurer, in addition to the initial first-party losses for the costs of the forensic investigation and notifying individual consumers who suffered from the breach. So that's what this case is about. Should those costs and fees are those covered by this particular insurance contract? And don't worry too much about the details, but as you read it, you'll see the court said no. Under the terms of what is covered and under what is excluded under the policy, the first party risk of investigation and all that is covered. No one disputes that. But this other risk is not covered by this insurance contract. And so the merchant is responsible under its agreement to reimburse the acquirer bank for that itself. So what lesson should you take away from this as a lawyer who might be advising clients like P.F. Chang's? The primary lesson is that you want to, as the potential insured, you want to understand the whole network of risks that you're facing from a data breach, which can include these first-party risks, but can also include a lot of other things that you might not otherwise think about, such as the risks from these networks of a card brand. It might, by the way, also include other kinds of third-party risks, like contracts with a vendor that might be outside of this network, where you may or may not have some indemnity from that vendor, and they may or may not have some insurance for what they're doing. All of that whole network of things are things that you want to consider when you're looking at what the scope of your insurance coverages is, and or the insurance coverages of vendors who are doing work for you. And this can be really difficult. And one of the difficulties is, unlike the general commercial general liability policies for, slip and falls in the store and things like that, which have been around for a long time, those terms are pretty standardized. There's a lot of legal case law interpreting them. The terms for cyber insurance are not standardized, and there's not a lot of case law interpreting them. So, you might think that you're buying something that would cover this kind of risk, but you might turn out to be wrong. You can't be totally sure in this space, but what you can do is scope out all the risk and try and make an informed decision. So the P.F. Chang's case, I think, is just one of the few examples of a reported case on cyber risk insurance, and it gives you a way to begin to think about, how do I consider the different layers of things that I might want to insure against, or at least be aware that I'm not insuring against. All right, so I hope you enjoy it this week, and I will see you online.